Professor Finkelstein, I just want to get your opinion on this decision today, the determination on whether former President Trump is immune from prosecution after special counsel Jack Smith indicted him on 4 counts related to the January 6th insurrection.
So, Leanne, what I said today on Twitter and in other interviews is that I think this is the worst decision that the court has rendered in many, many years, and it will go down as among the worst decisions in the court's history, along with Dred Scott, Lochner v. New York, um, and the Korematsu decision. This is going to be one of these decisions that is reviled for all of history because basically the Supreme Court has put the president above the law with regard to a whole host of actions that the president can take as long as he says that he is exercising his Article 2 presidential authority in doing that. What the court did was to create three categories: a category of constitutionally protected activity, a category of presumptively constitutionally protected activity, and then a category of personal capacity action in which the president is not constitutionally protected and is not immune. And the question, of course, will be what is the size of that third category? But in the first category, the highest level of protection, there is going to be a lot of damage because in that category, the president's actions are not even reviewable. And so not a court and not Congress, no one can gainsay the president's authority in this domain.
So this is directly about President Trump, but does this place presidents going forward above the law? Is that one of the main concerns, the biggest concerns about this sort of decision?
That is the biggest concern about this decision because I think for all time now, presidents will be able to violate the law, will be able to manipulate the law as long as they claim that they're doing it in the exercise of some presidential capacity, which is directly dependent on their Article 2 authority. And they'll be able to get away with that, most likely, because the court is making this unreviewable. So what's not clear is the degree to which federal courts will have the ability to set the boundaries around these three categories, or whether or not presidents will have the ability to say, well, I'm exercising my Article 2 authority here, and so that sets the boundaries of the category. But I think that presidents will have a lot of ability to claim that they are exercising in their not just their official capacities, but their constitutionally protected capacities, because it will turn on the reasons they give for their actions. And you can always find a constitutional basis for your action, given that the key constitutional phrases in Article 2 are so broad. The vesting clause, the take care clause, the commander-in-chief clause. These are very, very broad grants of authority. And presidents will be able to claim very often that they're acting in that capacity.